Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are picking up on Florida versus Stephan Sterns. This is a story coming out of Kissimmee, Florida, and it's disturbing. And it does involve a 13-year-old female and a 37-year-old male. If you guys don't know anything about it, next week we're going to be doing a deep dive because this trial starts, there's two trials. There's one that starts May 5th, and then there's one that starts September 22nd for Stephan Sterns. So next week we're going to pretty much dedicate the entire week to covering the backstory because it's a pretty deep backstory. But I will just do a quick overview for today. So we're showing two pre-hearings, pre-trial hearings. One happened yesterday, and it's only 12 minutes, and then it rolls over into today. So yesterday's, they were trying to suppress some evidence. That got kicked over into today. So the two are kind of related, but just to give you kind of a high level, Madeline Soto, or Maddie, she had just turned 13 years old. Literally just turned 13, I think, that day. So the date of this incident is February 28th. Stephan Sterns is the defendant. He was a couple. He was dating Jennifer Soto, who is the mother of Madeline, and Stephan's 37. So those three were all living together at some point. Now, for this trial that's starting May 5th, Stephan is accused of over 60 charges, and you can see the charges. 8 counts of battery on a child under 12, 5 counts of battery on a child aged 12 to 18, 7 counts of lewd and lascivious molestation, 40 counts of unlawful possession of materials depicting SA performed on a performance on a child, meaning 10 or more images, first degree, second S battery on a child under 12, neglect of a child with great bodily harm, and then tampering with physical evidence. So this one is going to be difficult on some level, but we're not going to shy away from it because we feel that Madeline needs to have her voice heard. So basically, again, the overview is Stephan Sterns. He's set to go to trial on May 5th. For more than the 60 related charges, which I just laid out for you. And then again on September 22nd for the first degree. So the state, which is Florida, is pursuing DP. Thank you, Lacey. Best chat ever. Appreciate that. Thank you so much. I know this will be a tough one for us, but 3 months, awesome. But we're going to give Madeline a voice here. So Madeline was 13. She allegedly was dropped off by Sterns near her Orange County, Florida middle school, right? So this is Orlando area. It's Kissimmee. Kissimmee is just a little bit south and I think west. It's basically Orlando. Just to give you guys a geographical orientation. And next week when we go into deep dives, I'll pull up maps and we'll get into this pretty heavily next week. But for now, we're just doing high level for now. So he dropped her off on the 26th, right? But the investigation took them, so then her mom goes to pick her up and she's missing, right? She's not at school. So they're trying to figure out what the heck happened. So then investigators, as they discovered more and more, they found out that Sterns deleted Madeline and then drove around with her body for hours. He eventually dumped her in a field. He is the boyfriend, they were boyfriend-girlfriend at one point, but at the time of this, they were not. He had been living with them in Kissimmee, Florida. Investigators say so while they're investigating this, they found pictures and videos on Sterns' phone that showed him abusing Madeline as far back as 2019. So again, we will get into a higher level, deeper dive. Right now, we're just touching upon some key moments, key points, and then we're going to go into the first pre-trial hearing, which was yesterday. And I'm going to show that first. So this is 12 minutes, and I want to play this because the live one is coming up at the top of the hour. So I'm going to go ahead and play this.
We're on the record, State of Florida versus Stephen Michael Sterns, 2024 CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Sterns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has case law provided a copy to the state already. You want me to give you a moment to read, Judge, or you want me to go ahead?
Just a moment. These highlight the McKay factors.
Essentially, Judge, they all essentially stand for the same
I'm familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a 2nd DCA case from 2020, McKay versus State, 1st DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025 Westlaw 1119091 from last week, from April of 2025. Trocola versus State, 867 Southern 2nd 129, 50 CA from 2004. And Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. In looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion, as well as in preparing the other case for trial. Defense is coming to information that at this time defense is in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of the homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Botham factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing the motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense would be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed. Discovery exhibits haven't been disclosed in regards to it because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was in trial with Your Honor as another case, and I filed the notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there's been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m. That will conclude our hearing.
All right, so we've got that. Let's get over to live now. So now they are live.
This suppression hearing. Now he is.
Sorry, hold on. Let me just rewind it just a bit. We just rewind it a hair. They came in just about a minute ago. Yeah, we're just like about a minute behind. Let me just... Okay, here we go.
Stephan Sterns is due back in court for a second straight day. Again, you see the judge inside the courtroom. This is for a suppression hearing. Stephan Sterns, the man, of course, charged in with the sexual battery and murder as well of Maddie Soto, 13-year-old who went missing. This is a suppression hearing to block evidence collected from Sterns' phone and his Google account. So this is Stephan Sterns here sitting at the defendant's table inside that courtroom. The defense says investigators unlawfully seized and searched that phone, while the prosecutors say Sterns gave consent, that evidence was properly obtained. You can see the shackles around his feet as he wears the orange jumpsuit where he has been in custody for. This is the case that's set to go to this suppression hearing. We will...
Sorry.
Okay.
Last Thursday.
All right, hold on. Let's see if we can get a... Yeah, they went to the FSU shooting. Dang it! All right, hold on, guys. Let's see if we can get it. They went to the FS. That's the local channel out of Orlando. Said they thought the FSU shooting was more important, which I'm not saying it's not, but maybe we can find something else. Just hang with us. See if we can find this. All right, hold on. Aaron's got it. Aaron comes to the rescue again. All right. Good job, Aaron. As always.
I got it.
Okay, yep, thanks. Aaron is the best. She found it. So let's go check this out.
You'll have to rewind it, obviously.
Yes. Aaron to the rescue. All right.
Effective on their face. Right, the court has three motions before it filed by...
Oh boy, this is going to be some brutal audio, you guys, so hang with us. I'll do the best I can, but this audio sounds pretty bad. Audio alert, just heads up. I'll do the best I can. Just hang with us while I work this audio.
Counsel on behalf of Mr. Sterns.
Thank you. Right, the court has three motions before it filed by the defense. The first, in chronological order, is a motion to suppress evidence obtained by unlawful seizure of a cell phone. The second is motion to suppress evidence obtained from unlawful searches of a cell phone. And the third motion, motion to suppress evidence obtained from Google search warrant. Some of the arguments are interlaced amongst themselves. The state of Florida has filed responses to each of the motions. In advance of this hearing, the court was provided with three audio recordings of interviews. The first recording of an audio interview was with Mr. Sterns and Detective Hunt. That was on February 27th at 12:05. Second recording was identified as 24-11313 underscore Stephan between Mr. Sterns and Detective Tagler and Detective Acosta. Third recording the court reviewed was identified as 24-1313 underscore Stephan number 2. And that was an interview that occurred on February 28th at 12:16 a.m. I have reviewed those recordings in their entirety. I have reviewed the defense's motions. Some of the interrelated arguments are that the seizure of Mr. Sterns' cell phone by law enforcement was initially pursuant to consent, but if that consent is deemed valid, that the scope of the consent was exceeded by law enforcement, that consent and subsequent consent were not a knowing, voluntary, or intelligent waiver of his Fourth Amendment rights. That's either that was by way of coercion or acquiescence to police authority or impairment by lack of sleep or ingestion of a sleep aid, and that no exigent circumstances existed to vitiate the need to secure a warrant prior to the seizure. Second motion deals with a request to exclude evidence pursuant to the exclusionary rule, pursuant to an unlawful search of that cell phone. Again, the defense argues that any consent scope was exceeded by law enforcement, that alleged consent was not a knowing, voluntary, or intelligent waiver of Mr. Sterns' Fourth Amendment rights against unlawful search and seizure, again, by way of coercion, acquiescence to police authority, impairment by lack of sleep or use of a sleep aid, and that no exigent circumstances existed for the unlawful search. Third interrelated motion is a fruit of the poisonous tree argument that the subsequent information obtained from a Google search warrant from the initial search and seizure of the phone was pursuant to a warrant. However, the taint was not diminished. The taint of illegal activity was not diminished by the subsequent warrant, that the warrant lacked probable cause, and that the application for the warrant itself were defective on their face. The state's response is also interrelated on these related motions, indicating that the initial interaction regarding the search and limited seizure of the phone regarding the Google search was consensual. That subsequent consent was knowing, voluntary, and intelligently given to law enforcement, that there was probable cause for the seizure of the cell phone, and that exigent circumstances indeed did exist. They further argue as to the motion to suppress evidence obtained from the Google search warrant, that there was indeed a warrant in this case, that the burden would fall upon the defense to establish standing, and that a recitation of their argument is not evidence to be considered to shift the burden. They also indicate that the warrant had the requisite temporal and peculiarity requirements, and if defective, that law enforcement relied on a good faith exception to conduct the investigation of the Google information. So as to the initial motion to suppress evidence obtained by unlawful seizure of the cell phone, does the state concede standing?
No, Your Honor.
Thank you. Defense?
The defense will invoke the rule of sequestration and call Mr. Stephan Sterns.
Thank you. The rule of sequestration has been invoked. If you are a potential witness in this case, we're going to ask you to please remain outside of the courtroom. Please do not discuss the facts of the case with anyone, including other potential witnesses. Ms. Smith, whenever you're ready. Mr. Sterns may be questioned from counsel table. We're going to swear in Mr. Sterns.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, can you please state and spell your last name for the record?
Stephan Sterns, S-T-E-R-N-S.
And Mr. Sterns, did you come into contact with law enforcement in January of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
No further questions, Judge.
Thank you. Any cross requested?
Yes, Your Honor.
Thank you. Ms. Pinnell?
Can I have just a moment?
Yes.
Mr. Sterns, you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Acosta on February 27th. Is that correct, of last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, as Acosta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Briefly, when she told me to input my PIN because it had locked itself.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct?
Okay, outside the soap.
Your Honor, can we approach?
Yeah, come on up.
Sorry, guys, the audio is just terrible. I've been fiddling with it this entire time. It's they have their gain like on 10,000, so it's like I can't do anything. It's like garbage in, garbage out. I can only fix it so much. It's better when it's lower because I can boost the gain and I can play with things, but when it's too hot, I can't do much with it. So just hang in there.
And the cell phone in question was in fact your cell phone?
Yes, it was.
I don't have any other questions.
Thank you. Any redirect? Thank you. Argument, state.
No, Your Honor.
Court's going to find that there has been record evidence to establish that Mr. Sterns was the person that was affected by an alleged violation of his Fourth Amendment rights, that the property alleged in that violation was admitted to be his, and I'm going to find that the burden has indeed shifted to the state regarding the defense's motion to suppress evidence obtained from the unlawful seizure and search of the cell phone. State, do you anticipate presenting witnesses or evidence?
Yes, Your Honor.
Thank you. Let me call your first witness.
The state will call Detective Francis Hunt.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, can I approach the clerk?
Of course. Attorneys on both sides are welcome to move about the well as they need to.
Good afternoon. Will you please say your first and last name and spell both of them for the record?
Francis, Francis, Hunt, Hunt.
How are you employed?
I'm a detective with the Orange County Sheriff's Office.
What was your assignment with the Orange County Sheriff's Office in February of 2024?
I was and am currently assigned to the Domestic Crime Squad.
How long have you been assigned to that particular squad?
About a year and a half.
How long have you been with the Orange County Sheriff's Office?
About 5 years.
Were you assigned to the investigation into Madeline Soto, who was reported missing?
Yes, ma'am.
Did you have the opportunity to come into contact with somebody identified as Stephan Sterns?
Yes, ma'am.
When did you have contact with Mr. Sterns?
The morning of February 26th, 2024.
February 26th, the Monday, or February 27th, the Tuesday?
I believe it was the Monday, it was actually the Tuesday morning, I'm sorry.
Tuesday. At the time that you had contact with Mr. Sterns, had the Orange County Sheriff's Office already been investigating the disappearance of 13-year-old Madeline Soto?
Yes, ma'am.
Did you have contact with Mr. Sterns and conduct an interview about 12 in the afternoon on February 27th of 2024?
Yes, ma'am.
And can you describe Mr. Sterns' demeanor during your encounter with him?
Nothing particularly notable. He seemed to have, I think he had just woken up about an hour before I made contact with him. He was an average demeanor, nothing particularly notable about it.
Was he cooperative with you?
Yes, ma'am.
Was he able to speak coherently to you and answer questions appropriately?
Yes, ma'am.
Did he seem to have any difficulty understanding the conversation that you guys were having?
Not at all.
Was this interaction that you had with Mr. Sterns audio recorded?
It was.
Where were you at when you had this interaction with him?
I was at his home or at Jennifer Soto's home in Kissimmee. We were in my vehicle.
Was this located at 4012 Santa Maria Drive in
That's it.
Kissimmee? And was anybody else present during your conversation?
No, ma'am.
Your Honor, I would like to approach the witness with state's name for identification. Did you have an opportunity to listen to the recording on state's A for identification?
Yes, ma'am.
Is it a fair and accurate recording of the conversation that you had with Mr. Sterns on February 27th of 2024 at approximately noon?
Yes, ma'am.
Your Honor, at this time, the state will seek to introduce an evidence of what's been marked states A for identification, and the evidence is states 1.
No objection.
A as an alpha will be received as States 1 for purposes of this hearing.
During your interaction, you had indicated that you believe, well, actually here in court today, you indicated that you believed he woke up about an hour before you had contact with him.
I believe so.
What makes you say that?
I had first completed an interview with Jennifer Soto. I had gone back to my vehicle to make a phone call, and I think Stephan was upstairs in the home while I was interviewing Jennifer. When I had gone back in, he walked back down from upstairs and said that he had recently woken up within the hour.
Can I have just a moment, Your Honor?
Of course.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So just to be clear, when you're doing this interview, you're inside of the house, right?
I was in my vehicle.
Okay. When you first met with Mr. Sterns, you met him inside the house? Then?
In the house, yes, sir.
Okay. And then you took him outside and put him in your vehicle, right?
Yes, sir.
And when you did that, that's when you learned about him being sleepy, it sounds like?
I don't think he was sleepy, but it sounded like he had woken up about an hour prior. Yes.
Okay. Woke up about 11 a.m.? It sounds like the interview was noonish, right?
Correct.
Okay. At any point, did you ever seek a warrant for any of the cell phones or anything in this case?
Oh, no, sir.
Okay. Did you ever look at a cell phone?
No.
Did you ever ask him about a cell phone?
No.
Brief moment.
Of course.
No further questions.
No, Your Honor.
May Detective Hunt step down?
Yes, Your Honor.
Is he excused from subpoena for today?
Yes, Your Honor.
Thank you, Detective. May I call your next witness?
State calls Detective Myra Tagler.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Will you please say your first and last name and spell both of them for the record?
Myra Tagler, M-A-I-R-A, last name T-A-G-L-E-R.
How are you employed?
The Orange County Sheriff's Office,
How long have you been with the Sheriff's Office?
9 years.
In February of 2024, what was your assignment?
I was assigned to the Sex Crimes Unit.
Are you still assigned to that particular unit now?
Yes, ma'am.
How long have you been in that unit?
3 years and 2 months.
Were you working in your capacity as a detective in that unit on February 27th of 2024?
Yes.
Did you become involved in the investigation into the missing juvenile named Madeline Soto?
Yes.
How did you become involved?
I was tasked to assist the primary detective at the time, Detective Hunt, with canvassing.
About what time do you respond to assist in the investigation?
It was about 4 p.m.
And this was on February 27th.
Yes.
And where is the initial location where you responded to?
It was in Hunters Creek,
Did you respond to a residence in Hunters Creek or somewhere else?
somewhere else.
Did you respond to the command post?
Yes.
When you get to the command post, do you learn any information regarding the investigation?
Yes.
What information do you have after leaving the command post? What information did you get?
I was advised of we have LPRs, which is tag readers, and I was advised of the direction of travel that Stephan's vehicle had traveled the day of the incident.
Were you aware on this date and time that Madeline Soto had not gone to school on February 26th?
Yes.
Were you aware that she had not been seen since the morning of February 26th?
Yes.
And the information regarding the tag reader, did law enforcement identify the tag that was on a vehicle that the defendant had access to?
Yes.
And what was some information that you got regarding the location of the defendant's vehicle on the morning of February 26th, the Monday?
He had traveled southbound 3 times on South Jungin Parkway towards Kissimmee, which was away from the direction of Madeline School.
Are all of these times early morning and late morning?
Both.
And then did you also get some information that in the afternoon the car was traveling in and out of St. Cloud, Florida?
Yes.
Specifically, the travel on southbound South John Young Parkway, were those times consistent with what the defendant had described to law enforcement as his location were?
They were not.
And were these, the initial time was around 8:15 in the morning?
I believe it was 8:10.
And then there was another one around 10 o'clock in the morning?
Yes.
And then almost around noontime?
Yes.
Thank you. Overruled as to leading, I've got a question. The times that you just gave were for identifications of the tag through the LPR system.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
Did you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes.
Your Honor, I'm approaching the witness for the record with Detective Tagler's 11-page narrative.
Thank you. I'm looking at page 4.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on the Tagler going in and out of St. Cloud?
Yes.
What times was it traveling towards or into St. Cloud?
It says eastbound on US 182 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Sterns in this case?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stephan Sterns?
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Ms. Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Sterns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes. Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephan Sterns?
Yes.
How did you know who was Stephan Sterns and how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Sterns audio recorded?
Yes.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Sterns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Sterns with you and Detective Acosta?
No.
Where is Mr. Sterns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Sterns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stephan Sterns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Sterns' path of travel impeded by either of you?
It was not.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
At some point during your interaction with him, do you request for Mr. Sterns to take out his cell phone
Yes.
or to look at his cell phone?
Yes.
Can you remember where the cell phone was, where the defendant's cell phone was when you asked this question?
I do not. It was in his possession, but I don't recall where he grabbed the phone from.
Did the defendant consent to allowing you to look at his phone?
Yes.
And do you remember if Mr. Sterns' cell phone was password or passcoded, protected?
It was.
Who entered the passcode into the phone?
Stephan.
After Mr. Sterns entered the passcode in the phone and unlocked the phone, what did Mr. Sterns do with the phone?
He handed me the phone.
While you are holding the phone, where are you standing?
In the same position next to Stephan.
Do you hold the phone in a way to allow others to see what is on the phone?
Yes.
Where is Mr. Sterns at as you are looking at the phone?
Directly standing next to me.
And initially, the interaction and how the cell phone comes out, you bring up looking at maps in the phone.
Correct.
Are you familiar with the type of phone that the defendant had?
I am not.
Do you also inquire as to taking a picture of, quote unquote, your history, the defendant's history? Do you remember that?
Yes.
And that's also encompassed in the audio recorded interview.
Correct.
Does the defendant ever communicate to you any limitations on what it is that you're doing?
He does not.
Does the defendant ever attempt, either verbally, physically, or in any type of way, to cease the search of the phone?
He does not.
After you look at the maps, the history, what did you see? Or what did you notice in what you saw on the phone?
I noticed that he had mentioned that he uses Google Maps for basically everything, to check locations, the time places open and close. And I noticed that on his Google history, it was very minimal. There was not a lot of traveling that was consistent to what he had originally said to both Detective Acosta and I. So then after that, I went to his call history, and I noticed that there was also not a lot of information on his call history.
And this was after you mentioned looking at his history.
Correct.
And during this entire time, did the defendant ever cease or withdraw his consent, either verbally or physically?
He does not.
After this initial interaction with the cell phone, do you keep the cell phone?
No.
What do you do with it?
I hand it back to Stephan.
Is it at this point that you walk away for a brief period of time?
Yes.
And do you come back?
I do.
Where Mr. Sterns and Detective Acosta are?
Yes.
Did anything about the circumstances surrounding this interaction with Mr. Sterns, either the location, the number of people, where people are standing, did any of that change?
No.
Was Mr. Sterns standing in a similar place as before you left?
Yes.
Was Mr. Sterns still free to leave and out of handcuffs?
Yes.
At approximately 7:57, do you again ask Mr. Sterns to unlock the phone?
Yes.
How does that happen? Explain that process.
He again enters the code and hands me the phone.
At some point, do you bring up the lack of call history to the defendant?
I do.
What was the defendant's explanation?
He said he had accidentally factory reset his phone.
After your interaction with him, you knew all of that information that you had previously explained that you knew. You had an opportunity to see things on the phone and the information that you had that the phone was factory reset. What did you do?
At that point, I told him I was going to hold on to his phone.
And that was approximately at 8 p.m., 7:59, 8 p.m. on February 27th of 2024.
Correct.
After this interaction with him, did you secure anything else?
No.
Other than the cell phone, did you secure anything else or?
Well, I did ask him to refrain from going back in his vehicle.
His vehicle meaning the Lincoln.
Yes.
Was Mr. Sterns able to enter and exit Jennifer Soto's vehicle during the time between your two interviews with him?
Yes.
Was he free to walk about?
Yes.
Did you or Detective Acosta remain where Mr. Sterns and Ms. Soto were?
No.
What were you doing in between your two interviews?
After speaking with Stephan Sterns the first time, Detective Acosta and I went to the front of the apartment complex to speak with management and ask them to review their surveillance.
After doing these additional tasks, do you speak to Stephan Sterns a second time?
Yes.
This is approximately 12:15 in the morning on February 28th, right?
Yes.
Was Mr. Sterns handcuffed?
He was not.
Had his movements been restricted in any way by you during your conversation?
No.
Were you wearing the same clothes that you had worn a couple hours earlier?
I was.
Who was with you when you spoke with Mr. Sterns?
Detective Acosta.
At any point in time during either of your interactions with Mr. Sterns, did you or Detective Acosta remove a firearm from your persons? Did you guys take your guns out?
No.
Did you threaten arrest or anything like that during your interactions with Mr. Sterns?
No.
This second interview that you conducted, was that also audio recorded?
Yes.
Was Mr. Sterns free to leave at the end of the interview?
Yes.
In fact, he did leave your presence as well as Nation Bay, correct?
Correct.
Was Mr. Sterns' demeanor the same or different?
It was the same.
Did you have any issue communicating with Mr. Sterns?
I did not.
Was Mr. Sterns cooperative with you?
Yes.
And during this second interview, did you explain what law enforcement was seeking to do with Mr. Sterns' phone?
I did.
What did you tell him?
I asked him I told him that we wanted to download the phone to see if we can get more information from his maps. And then he said that that was fine.
Okay. Are you sure that you specifically said that you wanted to download information, specifically the maps?
Not just the maps, just any information on his phone. I told him that we wanted to get more information from his cell phone.
Do you remember using the words, we want to download your phone, we want to go through your phone?
Yes.
During this encounter with him, you request specific consent from him to be able to go through the phone, right?
Yes.
Do you explain to him in your question what is going to happen or what your alternative route to obtaining that cell phone download is?
Yes.
What did you say?
When I explained to him what we wanted to do with the cell phone, I asked him if I had his consent to download the phone or if I had to obtain a search warrant.
And did the defendant consent to downloading the phone?
Yes.
Did the defendant provide you verbally with the passcode to his phone?
He did.
At the time that this interaction happened, did you or Detective Acosta impede or restrict Mr. Sterns' movement in any way?
We did not.
At any point in time, did Mr. Sterns seek to limit the scope of the cell phone download?
He did not.
Did you provide Mr. Sterns with your phone number or a way to get a hold of you after your interaction?
I did.
And did you give him any information as to when you would be accessible through that cell phone?
I did.
What did you tell him?
That my phone was on 24/7.
At any point in time, did Mr. Sterns reach out to you to either withdraw consent or limit the consent?
He did not.
Are you sure that he had a way to communicate with you?
Yes.
How do you know that?
Because Jennifer had her cell phone with her.
Are you sure that, do you know if Mr. Sterns and Ms. Soto left Venetian Bay together?
They did.
Do you know which vehicle they were in?
In Jennifer's vehicle.
I'm approaching the witness for the record with States B for identification. Did you have an opportunity to listen to the recordings on States B for identification?
I did.
Did they fairly and accurately depict the recordings of the two interviews that we discussed here in court with yourself, Detective Acosta, and the defendant in this case?
Yes.
Your Honor, at this time, the state received interviews and evidence what's been marked B for identification and evidence of state 2.
Be a composite exhibit with both recorders.
Yes, Your Honor.
Thank you.
No objection.
These and Bravo will be received as state 2.
Can I have just a moment? No other questions?
Cross-examination.
Good afternoon, Detective. So your interactions with Stephan Sterns, they were audio recorded, right?
Correct.
Okay, they weren't video recorded?
No.
Okay. And let's paint that picture. When you arrived on scene, you said that it was you and another detective present, right?
Correct.
Actually, I think it would have been 3 detectives, right? You, Acosta, and Hunt?
Hunt was already on scene. Detective Acosta and I arrived later.
Okay, so 3 detectives now on scene.
Correct.
Okay. And alongside those detectives, you said that they were patrol deputies, right?
Yes.
From the Orange County Sheriff's Office?
I don't recall if it was us or Kissimmee.
Okay. Were they wearing uniform?
Yes.
Did they have their badges?
Yes.
Did they have their guns?
Yes.
Did you have your gun?
I did.
And did you have their badge?
I did.
Okay. And when you arrive on scene, you said that you first went to talk to Detective Hunt, right?
Yes.
Okay. And then afterwards, at one point you start talking to Stephan Sterns, right?
Yes.
Okay. And this is outside of his house?
Correct.
Because it's not allowed to go inside his house at this point, right?
Not at this point. The house was not secured.
Right. And when you're talking about secured, that's for securing for searching the house, right?
Correct.
Okay. So the deputies are making sure that he's not going back inside his house, right?
Nobody's doing that.
Okay. So at what point, let me ask it this way, how did he get outside of the house?
I don't know. I wasn't there when he was outside.
To your understanding, how did he get outside?
I'm not sure.
The law enforcement have told him to?
I wasn't there.
Okay. And when you're talking with him, at no point did you say, you can go back inside, right?
I did not.
At no point did you say, you're free to leave, you can drive away, right?
I did not.
Actually, and you kept him from going inside his own vehicle, right?
I did.
Because that was being secured for searching too, right?
At that time, I just asked him to refrain from going back in his vehicle.
Okay, so you didn't even tell him it was for a search?
Not at that time. I wasn't sure what we had at the moment.
Okay. And then when you're talking with Mr. Sterns, you kind of give us a general overview that you said that he consented to searching his phone, right?
Yes.
Okay. Your specific question to him at first, going through the timeline, is do you mind if I look at your maps real quick, right?
Correct.
At no point did you say, do you mind if I dig through your entire phone at this point, right?
I did not.
Okay. And then when you get to the next question, it's do you mind if I take a picture of your history, right?
Yes.
Okay. Not take a picture of his lock screen?
No.
Not take a picture of his home screen?
No.
Not take a picture of his call history?
It was his history.
Not take a picture of his emails?
I did not.
Not take a picture of the entirety of his phone, just his history, right?
Correct.
Okay. And then when you get to the next thing, you say, is it okay, let me make sure this is right. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, right?
Yes.
And at that point, Mr. Sterns tells you that he is not logged into his Google, right?
Correct.
Okay. But then you keep pressuring and you say, is it okay if I check?
I asked. I didn't press.
Okay. You asked if it's okay you checked?
Yes.
Okay. And at that point, it was just to check whether he was logged into his Google, right?
Correct.
Not going through the entirety of his phone.
Correct.
You never asked him, can I go through the entirety of your phone?
He was standing next to me while I was on his phone.
Okay, so it's your basis that he has to say no, you can just keep digging until he says stop?
Correct.
Really?
He was standing next to me and he saw what I was doing on his cell phone.
And did you ever ask him to go through the rest of your cell phone?
I did not.
Did you ever ask him to go into his call history?
I did not.
Did you ever ask him to go through his Google Drive on the phone, if it even was there?
I never looked at his Google Drive.
Okay. But you were looking at the rest of his phone, right?
I looked at his call history and his Google Maps.
Okay, because you were trying to figure out that timeline, right?
Correct.
It's the only thing you were looking for at this point, right?
Correct.
Okay. Did you ever go into the photos on his phone?
Yes.
While he was there?
Yeah, he was standing next to me.
Okay. Did you ever ask him if you could go through his photos?
I did not.
Right. And when you're going through those photos, I mean, let's talk about that. How many of his photos did you look at?
I think it was maybe 2 or 3 of the day Madeline went missing.
Just to be clear, you're not just looking at, like, the big grid. You start going into actual pictures?
I don't recall if I actually clicked on any of the pictures.
Okay, so how do you know that you were just looking at 2 or 3 of the photos?
Because it has dates on, like if you look at the grid, it shows dates for pictures.
Okay. And at any point, I'll just rephrase, at no point did you ask him to look at his photos?
I did not.
Then you go back to his Maps app at some point, right?
Correct.
And at that point, you're talking to him about the Snug Street address, right?
Yes.
Okay, and you never asked him if he could go back to the Maps app at that point, right?
I did not.
Okay. And just to be clear, nothing is visually recorded at this point. Right?
Correct.
So when you say that you handed him his phone back, you never actually said, hey, here's your phone back, or anything of that.
I did. I said, here you go.
Here you go. Now, when you get the phone back from him, what do you say?
I said, can you please unlock your phone again?
Okay. And at that point, it's still you and Detective Acosta standing with him, right?
Correct.
Because you both are kind of tag teaming him, questioning him, right?
We're both talking to him.
Okay. Specifically, at what point did you say, here you go, when you handed him his phone back?
Right before I stepped away.
Okay. You sure here you go are your exact words?
I don't know if it was my exact words, but I did hand him the phone and I said, here you go. It's in the audio recording.
Interesting. Okay. And then at this point, you said you got him to unlock his phone again, right?
Yes.
And that's when you started digging through his call history, right?
I'm not sure what I looked at when I had the phone back.
Well, you specifically said, I also noticed I was checking your call history. I noticed you don't have anything before this morning, right?
Yes.
Okay. And at no point did you ask if you can go into his call history?
I did not.
took the phone from him, what time was that?
About 8, a little after 8?
8 at night?
Yes,
Okay. Just to make sure we're painting that picture clear too. 8 o'clock at night you're speaking with him, right?
correct,
It's about 50 to 60 degrees outside?
correct.
Okay. And law enforcement's been standing around with Mr. Sterns outside?
He went to Jennifer's car after me and him spoke.
Okay, but before you and him spoke?
I can't answer that question, I wasn't there.
Okay, when you first showed up, where was he?
Outside?
Outside where?
I don't recall the exact location, but he was outside with Jennifer.
Right, so you know exactly where you walked, but not where he was?
Correct. I walked towards Detective Hunt.
Now, at this point, you collect Mr. Sterns' phone away from him for the final time that he has his hands on, right?
Correct.
And when you take that phone away from him, you don't ask him for his phone. You take it from him, right?
I already had the phone.
Oh, right. And then you told him specifically that at this point, we're keeping your phone.
Correct.
Okay. Didn't give him a choice.
I said, I'm going to keep your phone. We want to download your phone.
Excuse me, what was the exact phrasing that you just said there?
That we wanted to download the cell phone.
You said that during the first interview.
The second interview, not the first
Second.
one.
Talking about when you took the phone away from him, the first time, during the first interview. When did you tell him that you were going to download the phone?
The second time.
During the first interview, when did you tell him that you were going to download
The second time I spoke to him, not the first time.
You never said it the first time.
I did not.
Right. And then when you're talking with him that second time, you actually state to him, your exact words are,
Objection improper.
response? I'll reference it. When you speak with him, did you tell him that we had previously said that we were going to download the phone?
Yes.
And your interactions with him were recorded.
Correct.
And when you originally took the phone from Stephan Sterns, Mr. Sterns was concerned about staying in touch with his father, right?
Correct.
Okay. And that's the point where you told him, well, you can just talk to him through Jen's phone, right?
Yes.
And at no point was he asked to consent to seizing his phone, right?
Correct.
At no point did you ever give him any form or anything to consent to seizing his phone?
I did not. Everything's audio recorded.
Okay. And at no point did you ever get a form from him consenting to downloading his phone?
I did not.
Okay. Because everything's audio recorded.
Correct.
Got it. And you collect the phone at 8 at night. It's about 1:30 in the morning you talk to him again.
It's not. It's about midnight.
About midnight, okay. 4 hours then?
Just about.
Okay. You have the phone in your possession?
It was in my vehicle.
Okay. Ever apply for a search warrant at that point?
I did not.
Why not?
I didn't need, I didn't have like enough information yet as to what we were doing with the case.
Elaborate on that for me. What do you mean you didn't have enough information?
We knew that something didn't sound right, as like was speaking with him with like the timeline and things like that. But we weren't sure exactly what we were doing yet. I was waiting for my supervisor to contact me.
Okay. And when your supervisor contacted you, did he or she, excuse me? He? Did he tell you to get a warrant?
He did not.
Okay. Did he tell you to try and get that cell phone download?
He did.
Okay. And how did he tell you to get that cell phone download?
He didn't. He just said we wanted to get the phone downloaded, and that's when I asked Stephan if I had his permission to download the phone or if I needed to get a search warrant.
Right. You gave him the ultimatum at that point, right?
I asked him 2 questions.
Okay. So we can either get the phone or you can get a warrant, right?
Correct.
Now, at any point during these interactions, did you ever tell Mr. Sterns that he could have his phone back?
I told him his phone was going to be downloaded overnight and that he should probably get it in the morning.
Okay. And prior to the second interview, did you ever tell him he could have his phone back when you just took it from him?
I did not.
Okay. At any point, did you ever apply for a search warrant to download Mr. Sterns' phone?
I did not.
Did any other detective do that?
No.
Okay, because you're relying on that consent, right?
He gave us consent to search his phone.
It's a yes or no. Were you relying on the consent or did you get a warrant?
He gave me consent.
Now, when you're speaking with him, you became aware that Mr. Sterns had taken medication, right?
He said he had the night before.
Okay, and that was Ativan?
Yes.
And he told you why he took that medication, right?
Because he said he couldn't sleep and that he was very stressed and couldn't stop crying.
Right, and he was also having panic attacks, right?
Yes.
Okay. And you knew that?
Yes, the night before.
Why your question? During the first interview?
Correct.
And the second?
Correct.
Got it. You aware what Ativan does?
I don't take Advance, so no.
Okay. You ever deal with anybody that taken Ativan?
No.
Objection relevance.
As to Mr. Sterns, he was wearing flip-flops at the time, right?
Correct.
Khaki shorts,
Yes.
thin hoodie.
Yes.
Told you he hadn't eaten all day, right?
Yes.
And was prevented from going inside of, sounds like his vehicle, right?
His vehicle, correct.
Okay. And again, couldn't go inside his own house. Or not his house, but the apartment.
Not at the time.
Okay. And at what time, rephrase, at 2:40 in the morning on February 28th, you submitted his phone to the Orange County Sheriff's Digital Forensics Unit, right?
I did not.
You did not?
No.
Who did?
Detective Acosta.
Okay, so Detective Acosta was now in charge of the phone?
Yes.
Okay. You guys ride in the car together?
We did not.
You said the phone was stored in your car at some point, right?
When we were talking, or when we were looking at the video, yes, it was in my vehicle.
Okay. When did you turn over the phone to Detective Acosta?
At the end of the night, after we secured the residence, which was around 1 in the morning, Detective Acosta was waiting for the tow truck for Stephan's Lincoln, and that's when I handed him the phone because he was going to Central Operations, and I was not.
Okay. Was that the last time that you had involvement with the phone?
Yes.
Okay. So after the handoff, nothing else, just to be clear.
In reference to, like, if I ever looked at the phone again?
Yeah.
Sure, I think it was like 2 days later.
Okay. So at that point, the phone's still in your law enforcement's possession?
Yes.
Brief moment to confirm? Of course. No further questions.
Thank you. Redirect.
Defense mentioned that there were other law enforcement personnel that were at the apartment complex. During your interactions with Mr. Sterns, who was in the immediate area?
Just myself and Detective Acosta. Everybody was kind of just hanging out in the area.
Detective Tagler, I've got a question. When you initially interacted with Mr. Sterns, you indicated that you were going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
Was that on your agency cell phone?
Yes.
follow-up questions based on that question? State.
No, Your Honor.
Defense? No. Thank you. May the detective step down?
Yes, Your Honor.
Is Detective Tagler excused?
Yes, Your Honor.
Detective Tagler,
Thank
step
you.
down. Thank you. Witnesses are up.
Yes, Your Honor. Detective Lewis Acosta.
Raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Will you please say your first and last name and spell both for the record?
Louis Acosta, Luisacosta.
How are you employed?
Orange County Sheriff's Office as a detective.
How long have you been with the sheriff's office?
5 years.
In February of 2024, what was your assignment?
I was a detective with the Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you become involved in the investigation of missing juvenile Madeline Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Sterns. Just, that basic information.
Okay. Did you also get information regarding LPR tag reader hits on Mr. Sterns' Lincoln?
Yes.
And you also got the timing of those tag reader hits?
Yes.
Did you respond along with Detective Tagler to 4012 Santa Maria Drive in Kissimmee?
Yes.
And did you learn any additional information prior to speaking with Mr. Sterns at that address?
Yes. Prior, we were briefed of Detective Hunt, who's the initial primary detective assigned, just of additional details. For example, that she slept in the same bed as Mr. Sterns, things like that.
Did you assist in the interview of Mr. Sterns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes.
And this would be on February 27th of 2024.
Yes, correct.
Where did this interview take place?
It took place in the parking lot of their of the apartment complex near the residence, Maddie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Sterns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity of where we were at.
How many law enforcement officials would you say were in the parking lot area where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Sterns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this encounter?
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Sterns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Sterns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
If you asked a question, did Mr. Sterns respond in a way that was coherent?
Yes.
Did you have any difficulty communicating with Mr. Sterns?
No.
Did Mr. Sterns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Sterns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on the phone?
Mr. Sterns had the phone, and then he gave the phone to Detective Tagler after she asked, and he said yes.
Did Mr. Sterns have to do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing while Detective Tagler was viewing the content of the cell phone?
They were standing shoulder to shoulder next to each other.
Were you asking questions at that point?
Yes.
Were you able to see the content of Mr. Sterns' phone?
At some point.
Were you standing next to where Detective Tagler and Mr. Sterns were standing or somewhere else?
Yes, next to both of them.
Was Mr. Sterns facing the general area of where his cell phone was being displayed from?
Yes.
There is a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Sterns.
Do you continue to have a conversation with Mr. Sterns?
Yes.
At any point in time, does Mr. Sterns discuss the content of the cell phone or Detective Tagler's looking through the phone?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought out again?
Yes.
At this point, who had the cell phone?
Still Mr. Sterns.
When Detective Tagler asked for Mr. Sterns to unlock the cell phone again, does he do so?
Yes.
Does he have to enter the passcode again?
Yes.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr. Sterns' cell phone, correct?
Yes.
What information did you have together about the Madeline Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see her. There were many inconsistencies surrounding the time frame that he stated. He dropped her off and other things. And then the tag readers and information that we had about his movement.
Had the defendant been straightforward with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
Did you confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone when Detective Tagler checked that?
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you also present with Detective Tagler at the conclusion of this interview between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same.
Were they in the driver's seat or passenger seat?
Passenger seat, front passenger seat.
What about their appearance makes you believe that they were not awake?
slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews.
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where there was a brief conversation. Did you have a brief conversation with the defendant about what was seen in Madeline Soto's phone?
Yes.
What did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as...
Okay, something just happened there. Hold tight, guys. We just lost that. All right, hold on. We have another feed. That's weird. Nope,
She
now it's
explained,
back.
It would be taking the phone, be getting it back whenever the phone download was complete.
Did Mr. Sterns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to this phone?
Yes.
And all of this is recorded, right?
Yes.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview, while Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to just some sort of update. There you go.
As a law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigations?
Yes.
When a cell phone is taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Sterns, that was audio recorded, right?
Yes.
Not video recorded?
No.
Okay. And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Sterns?
I did not.
When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search it, right?
Yes.
Okay. So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews. They had crime scene up.
Okay. Some point it got crime scene tape, though.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were kind of in one group, and then uniform patrol were kind of in the perimeter for scene security.
And while State asked you if you ever removed your firearm, I just want to clarify, you had your firearm on you, right?
Yes.
And you're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or?
Yep. On my hip, yep.
Yeah. So it's visible?
Yes.
And you said that while you're questioning, well, you and Detective Tagler were questioning Mr. Sterns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagler's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagler's taking a look at the phone, you're close enough to see the phone, right?
Yes.
Okay, so you can actually see what's happening on the screen?
Yes.
Okay. So it's not like when we're saying that you're standing around the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here. You're all grouped up together, right?
Correct.
Now, it was during that first interview that you learned that the phone was factory reset somehow, right?
Yes.
Okay. And when y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Sterns.
Okay. At the entirety of both first interview, second interview, everything. When you're taking the phone to the sheriff's.
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
Okay. But between the first interview and the second interview with Mr. Sterns, it sounds like there's about maybe a 4-hour gap, right?
Yes, somewhere around there.
Somewhere around there. And at that point, you said that you went to the management to kind of take a look at the video surveillance, right?
Yes.
Okay. It'll take 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing kind of next steps, things like that,
Right.
discussing the case.
So when you're saying debriefing, right? Just you and Tagler, or are you talking to other people?
Other people, the unit,
Okay, so where does that happen?
in the management area.
Okay. So at that point, while you're debriefing, roughly how many law enforcement personnel are there?
I don't recall the number.
Can you remember anybody that was there off the top of your head? Sure.
Detective Tagler, myself, direct supervisors, so maybe a corporal and a sergeant.
Okay. So at least 2 other people present?
Yes.
Okay. And it's at this point, so that's where you all were talking to supervisors, right?
Yes.
And at that point, it sounds like one of the supervisors was like, hey, we need to go get that cell phone, right?
But yeah, I believe it came up during the conversation.
Okay. And then during that conversation, did anybody ever mention, hey, let's get a warrant to download that?
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
Okay. And did you ever ask Mr. Sterns if he could download the entirety of his phone?
I did that conversation was had with Ms. Detective Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you ever attempt to draft a warrant of anything?
I did not.
For your phone to confirm? Sure. Between the first interview and the second interview, you had never, neither you nor Tagler ever gave the phone back to Mr. Sterns, right?
Correct.
You held on to it the entire time.
Yes.
No further questions. Thank you.
Did you conduct any interviews between the first and second interview with Mr. Sterns?
Yes.
Who else did you interview?
Jennifer Soto.
So that was also during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around the 3rd hour, at the conclusion of the first interview, did you observe anyone direct Mr. Sterns that he could not leave?
No.
And when you returned after 4 hours, Mr. Sterns was where?
He was in the same parking lot area.
Any follow-up questions, Dave?
No, yeah.
Follow-up questions, defense?
During that time span between the two interviews, did anybody tell him that he could leave?
I don't recall that.
Thanks. May the detective step down?
Yes, sir.
Is he excused from this? Thank you, Detective.
Thank you.
Additional witnesses are up.
Yes, Your Honor. Sergeant Darko Staminate?
Please raise your right hand for this morning.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Will you please say your first and last name and spell both for the record?
Darko Stamenic, Darko Stamenic.
How are you employed?
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensic squad?
since June of 2023.
What type of training have you undergone to perform some of your duties in the forensic team?
So going back to college at the University of Central Florida, I minored in IT. After that, I went to Cellbrite School, where I became a Cellbrite certified operator as well as Cellbrite certified physical analyst. Those are two certifications that we have to use some of the tools that we use. And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer forensic examiner certification as well.
Did you download any phones as part of the investigation into the disappearance of Madeline Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time that download was completed and viewable?
I believe around 5 o'clock in the afternoon.
That's a couple hours.
A couple hours, right?
Okay. So, can you explain how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any. Extract the data from the phone. Then we take that data and we have another tool that parses that data, basically makes it readable by a human.
Is the time that it takes to extract the data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically with Madeline Soto's phone download, after it was completed, did you have the ability to share the data with other law enforcement officials that were working that same investigation?
Yes, I did.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field can view it.
Did you do that with Madeline Soto's cell phone the same day that
Yes.
you covered the data?
Yes, I did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Sterns' phone in this case?
Yes, I did.
Do you recall when you received Mr. Sterns' cell phone?
Yes, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes.
So you waited for Detective Acosta to come from Kissimmee?
Correct.
What did you do upon receipt of the phone?
I began extracting the phone, and then I went home.
Sorry to interrupt. 2:28 at 3 a.m.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connect it to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after you plugged the phone into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you were at that?
Yes,
Was it completed?
it was.
Can you explain, for this particular phone, I believe it was a Samsung type phone,
Correct.
how do you factory reset it?
Yes, so you have to go into the settings of the phone. I believe the next button says general settings, so you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset.
It is, yes.
Is this possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items are subsequently deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed up?
They do.
If a phone is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So, for example, the pictures, if pictures are backed up, if the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
It has no further questions.
Thank you. Cross-examination.
Good afternoon.
So, you're in charge of doing the forensic downloads on the phone?
Correct.
Okay. And when you're doing those forensic downloads, you said that there's a tool that you plug the phone into to fully download the phone, right?
Correct.
So it's not just downloading the information that's immediately accessible to the user, it's downloading everything, right?
Correct.
When it's doing that download, does it do a bit-by-bit copy of the entirety of that drive?
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a full file system extraction, so it's not a bit-by-bit copy.
Gotcha. So when it does that, though, if the phone's factory reset, you can still pull that information off the phone, even though it's not immediately accessible to the user?
Like, I'm sorry, what information?
The information prior to the factory reset.
Oh, no, not necessarily, no.
Okay, not necessarily, but in this case, you were able to pull information prior to the factory reset, right?
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud, and then it repopulated on the phone automatically after the reset.
Okay. Do you know at what time it repopulated?
It was, I believe, around 2 a.m. After the reset. I believe the reset was around midnight, and over the next couple of hours, the phone repopulated.
When you're saying 2 a.m., same day that you downloaded it or before?
No, it would have been when the phone was reset, and I don't want to speculate the date.
Gotcha, no problem. When it comes to a phone being factory reset, are you on any kind of timeline to make sure to recover data?
Not really, no.
Okay, so that's not a concern to law enforcement, right?
No.
Okay, so once it's factory reset, doesn't matter.
Right.
Of course.
When you did the download of this phone, anybody give you a warrant alongside the phone?
No.
No further questions.
Redirect.
No, no.
Witness, step down.
Yes, sir.
Sergeant Stenek, excuse me.
Yes, sir.
Your Honor.
We're going to take a 5-minute recess. This court is in a 5-minute recess.
Just making sure. Am I going too fast? Yeah. Just making sure. I know sometimes I can get on a roll. A little bit. Just making sure. Yeah, exactly.
Oh, girl. Not great. I fake it. Next time I might give you like a little. Yes. I wasn't prepared to do it, but we stay there, like give me a call, give me a it's okay. She just came in by you and she's like, go. No one. Exactly. It's it. Hey. What's everything I've been trying to do? Nothing's gone. So yeah, just hang out. Well, you made it.
That was fun. I always like a hot mic. We were behind about 2 minutes or so, 2 or 3 minutes. So I think that was the court reporter. She seems like she's full of life. Did she just gallop? Maybe. I always like a hot mic. So while we wait, that's Alicia Smith, and the gentleman that's representing him today is Ryan Anderson. So it seems like he's got a team. He has at least those two, and then there's Elizabeth Bordone, and then Melissa Vickers, I should say, is also on the team. Irish Amy, yeah, I live for hot mics too. It's like you catch people at, when they feel like they're dancing like, nobody's watching. Hey, Gordon, how you doing? Mr. Pancake, I just want to say that out loud. Ryan seems to be charming the court reporter, Irish Amy says. Yeah. You like Mr. Smith's hair better than yesterday's space buns? I like the space buns. I thought those were kind of cool. Who has the guts to wear space buns in a court? Got to give it up to her. I think they kind of figured out the audio, right? At the very beginning, the audio was terrible, but they kind of sorted it out. Yeah, they're all public defenders, Northwest. As far as I can tell, they're all public defenders. Melissa Vickers, Alicia Smith, Ryan Anderson. I still have to, therapist, if you could find out, or anybody for that matter, who the woman prosecutor is. I couldn't get that. Haven't gotten that yet. I guess William J. is going to be prosecuting this as well. We know him from Sarah Boone. Attorney J. Space Wars versus Space Buns. Nice. That's a good one, Northwest. Yeah, if we could find out who the prosecutor is, the female. I have not been able to find her name. You saw Mr. Wait. You saw Mr. Pancake arrest last year and couldn't resist? There's an actual Mr. Pancake? Oh, now I have to look that up. There's an actual Mr. Pancake? What is a Mr. Pancake? It's a restaurant. Mr. Pancake is a restaurant? In Wisconsin? Is that what it is? Oh, it's temporarily closed. Oh, there it is. Mr. Pancake, you're under arrest? Is that what it is? For animal abuse? Oh, no.
Your Honor, I would seek some clarification from the court as to whether we're going through all three motions today or just the first two that we're going over, because the state's position is that the burden is substantially different for the challenge to the warrant.
Understood. Do you believe that you have presented the witnesses for the first two motions?
If the first two motions are the seizure motion and the consensual search motion, yes.
Thank you. Defense, in your motion as to the motion to suppress evidence obtained from the Google search warrant, there was some argument that the defense does not have the burden or has satisfied its burden. I'll entertain argument as to that.
May I brief on?
Sure.
When it comes to the burden for attacking the warrant itself, the primary basis for the state's argument is on four corners of the warrant affidavit. So when it comes to the burden itself, we would be arguing that it's satisfied at least for the arguments we heard at this point, considering not challenging the actual document itself.
Understood. So, did you anticipate presenting witnesses or evidence in support of that motion?
No.
Okay. So you're just going to present an argument?
Yes, sir. Based on, right now we have the chain of how the warrant came about, and then getting to the cell phone download, and then there's the warrant itself.
Okay. So you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
And rely on the evidence that's been adduced in cross-examination to support the probable cause, or the lack of probable cause for the...
Exactly.
Does that give the state any clarity?
No, Your Honor. Florida Rule of Criminal Procedure 3.190 subsection G3 specifically states if the court hears the motion on its merits, the defense shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence that the defense's burden is to show that there's grounds for suppression of the warrant. I don't believe that that burden has been met for the state to be required to present rebuttal evidence. The affidavit is not before Your Honor.
Understood. All right, so as to sufficiency of the warrant, what evidence does the court have to make some determinations as to the sufficiency of the warrant? Talking about the technical defects that are alleged in the motion.
Yes, Your Honor. At this point, it's actually part of the court file, so we'd be asking not to take judicial notice of the search warrant.
It's not part of the court file. Search warrants are not part of the court file.
Absent some affirmative presentation of evidence regarding the argument that there is some kind of technical deficiency that makes the search warrant of the Google activity unlawful, it's going to be hard pressed to make a determination as to that. Let me ask the state. Are you requiring the defense to recall the witnesses that have just testified, or if they confine their argument to information that was elicited either in direct on cross, does that satisfy their burden, or shall we go through that entire exercise again?
Can I have a moment?
Sure.
Your Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However, there is no information before the court about the Google search warrant at this point. So the state's position is that they have not met their burden pursuant to the Florida Rules of Criminal Procedure to shift, to require the state to present rebuttal evidence at this point.
Additional testimony, the court's going to rely on the testimony that's been provided. There was a cross-examination and a redirect. That information is in the record. The defense can make argument that satisfies their burden or not. Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
The defense makes argument that the Google warrant relied on illegally obtained evidence and that there was no attenuation or intervening circumstances that urged the taker. The court has heard testimony from the investigating detectives that challenges the legality of both the search and seizure. That appears to be what the challenge on the warrant refers to, and that it is invalid as fruit of those illegal searches. As far as the application failing to establish probable cause, the court does not have the application. As far as the legal standard, probable cause in digital search warrants, the court is uncertain what kind of warrant this was or whether it was a digital search warrant. The argument that it fails to establish the sufficient nexus between the Google account and criminal activity, I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language, again, the court would have no evidence to support that argument. The temporal scope of the court would have no evidence to support that argument, and peculiarity for digital searches. Without additional information, the court would find that there's no evidence to support that argument. As to the evidence supporting the arguments that the search warrant is invalid based on lack of probable cause, based on reliance on illegally obtained evidence or intervening circumstances purging that taint, and being invalid as fruit of an illegal search and seizure, I think that evidence has been adduced in combination with the first two motions. So as to those issues, the court will find that there's been record evidence that supports that argument.
Given the hour at this point, the defense will be asking if we can buy for the first two motions and third, given the seven.
These three motions were set together, and we're going to address all three.
Given the court's ruling, the state will call its next witness, Detective Taylor Heller. Heller.
Please raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Right this way.
Please say your first and last name for the record.
Taylor Heller.
Can you spell both for the record?
First name is Taylor. Last name is Heller.
How are you employed?
With the Orange County Sheriff's Office as a deputy.
Were you employed with the Orange County Sheriff's Office on February 28th of 2024?
Yes.
Can I approach a witness with both the marked state C for identification? Sure. Can you take a look at state C? Did you draft the affidavit for search warrant encompassed in states C in relation to the Madeline Soto investigation?
Yes.
Is this state C a fair and accurate copy of that affidavit?
Yes.
Your Honor, at this time, the state seeks to introduce into evidence what the marked state C into evidence is the state's next number exhibit.
No objection.
We received this case three.
No further question.
Thank you. Cross-examination. Thank you. Will Detective Heller step down?
Yes, Your Honor.
Is she excused from us?
Thank you.
Additional witnesses or evidence?
No, Your Honor.
Witnesses or evidence defense?
Mayor.
Thank you. Parties need a moment to gather their thoughts for arguments, or are we ready to go? Sure. Take a 5-minute recess. Each side will have 20 minutes to present their argument. I'll ask that you compartmentalize into the individual motions. That's going to take a brief recess. Going to a brief recess.
We're going to keep it at a hot mic here. Hey, Selena, it started at 2. He gave 3 hours. So now they're going to do some closing. All right, so basically, state brought up 4 witnesses, and then judge was asking about the sufficiency of the warrant, technical defects, a lot of mumbling. Then, given the state came in and said, giving the court's ruling, the state calls its next witness, and it took me longer to type her name than it did for her to give testimony. But she basically, I think, drafted the affidavit. I'm pretty sure that's what happened. We heard from Detective Louis Acosta. We heard from Detective Mara Tagler. We heard from Detective Francis Hunt. And basically, they were all testifying that they went to Sterns's home around the 27th, 28th, and they asked him about his cell phone. He willingly gave his cell phone over. They didn't ask for a search warrant. They didn't need a search warrant, they said, because it was all on body cam. And that's pretty much it. That pretty much wraps up what they were. I guess, okay, so they were specifically looking for maps because it wasn't jiving with what he was saying. He was saying, oh, he travels all over the place for his work, and then they looked at his cell phone, and there was hardly any movement on his Google Maps. So then they they figured out that he did a factory reset, and they had a Cellbrite expert, that was Darko Stemnik. He came in. He says it takes multiple steps to do a factory reset. So we had two polls, 56 votes. Will this motion to suppress Sterns' cell phone be denied? 56 votes. No allowed in. 67% said it will not be denied. It will be allowed in. 32% of you thought it will be denied. So then the next one was, what's more difficult to do on a cell phone? Factory reset or butt dial at 2 a.m. while having relations? 41 votes. 46% of you said a factory reset. 43% of you said a butt dial. So, and yes, those body cams were only audio. Thank you, Northwest. Yeah, there were no video. It was audio only. And if you guys do go back to watch this at the beginning, the audio is terrible for like the first 5 minutes or so. Absolutely terrible. Then it finally kicks in. So if you are doing a rewatch and you go back to watch the beginning, it's pretty brutal. You can barely hear. So all right. So that's we're kind of caught up. This is scheduled to start the week of the 5th, right? Yeah. Week of the 4th, I should say, May 5th. So 2 weeks from now. So for those that are interested, we are going to be doing a deep dive next week. We're going to just dedicate ourselves to Stephan Sterns. And we're going to show as much as we can get our hands on. We've got Joe Schmo was kind enough to download some docs for us. He did a bunch of FOIA requests. So we're going to look at those. Therapist and OnlyFan have gotten us also some information. We're going to show those. We're going to show all the videos. We're going to show Jennifer Soto's interviews. Yeah, it's going to be interesting. Selena K, I do not think so. They haven't shown the gallery, so I have not seen. Renee, he handed his phone over. It should be allowed. One would think, but the way the defense argued it, as defense do, that's what they do, right? Sandra, so the cell phone going to be allowed in or not? We don't know yet. We have to wait. Hold on. What's this? All right, looks like we're back.
I don't have a preference. Who makes argument first?
This time defense is moving to suppress the evidence obtained by way of the Google extraction and the entirety of the data that was elicited from Google that was sought by a warrant. Defense is also seeking to suppress the actual cell phone itself and the data contained therein. For the first two arguments as to the unlawful search and seizure of the cell phone, defendant is relying on the United States Constitution, Fourth Amendment, as well as the Florida Constitution, Article 1, Section 12, specifically that as we go through this is all kind of intermixed between the three motions, but looking to the first motion as to the seizure of the cell phone, at this point, now that the burden has shifted, the state bears the burden to prove an exception to the warrant requirement in order to seize the personal property of Stephan Sterns. As to the seizure, defense would argue that no consent was either sought nor given for the seizure of the cell phone, as well as the fact that there is no exigent circumstances that would create this to be a constitutional seizure. As to Detective Tagler, the exact evidence that was elicited was that the detective had informed Mr. Sterns unilaterally that she was going to hold on to a cell phone. This was a declarative statement, not a request, and there was no opportunity to refuse the turning over of the cell phone at that point. Detective Tagler had the cell phone in hand, was clearly exercising dominion and control over the cell phone, and told the defendant straight up that it didn't matter that he wanted to get in touch with his parents or to continue getting in touch with his parents as the night went on, and simply dismissed Mr. Sterns' concerns and unilaterally seized the phone. The seizure of the phone itself occurred at approximately 8 o'clock at night. I believe it was 19:59 hours on February 27th. And as of the morning of February 28th, the phone was still in law enforcement's possession. As it was taken to digital forensics at the Orange County Sheriff's Office, the phone was still in law enforcement possession, which we start getting to a point where we're looking at several hours worth of seizure. The state, or the defense, in its motion to suppress based on the unlawful seizure of the cell phone, had cited to the United States v. Place where the seizure of personal property in that case was found to be unreasonable for a time span when this personal property was held for 90 minutes. We're well beyond 90 minutes at this point, and there was no attempt to minimize the intrusion of the seizure of the cell phone. Looking to the state's response, I understand that the state is going to be arguing exigent circumstances, but there was critical testimony elicited from the digital forensics examination witness who stated that once a factory reset occurred, to law enforcement, there was no hope of getting anything after that. During the first interview before the cell phone was seized, law enforcement knew that the cell phone had been factory reset. They dug through his cell phone and they confirmed that it was factory reset. At that point, no exigent circumstance existed as to imminent destruction of evidence, because at this point, essentially, Your Honor, it was destroyed in law enforcement's eyes. The gentleman testified the fact that there's no time span or immediacy when it comes to learning that the evidence could have potentially been destroyed when it comes to a factory reset. Additionally, the timeline itself of law enforcement's involvement in this case entirely negates the urgency element for the imminent destruction of evidence. From the time that the missing report came in to the time of the seizure of the cell phone itself, it was approximately 20 hours had elapsed. There was no immediate action taken to collect this cell phone, and this lack of immediacy completely contradicts the claimed imminent threat by the state. Additionally, when it comes to the seizure of the phone, there was no warrant ever sought. There's no warrant that was presented. This was, again, unilateral action, even though there's been an emergency judge ready to go on duty since the 80s in the 9th Judicial Circuit, both for Orange and Osceola counties, for law enforcement to seek a warrant, and yet they chose not to. When it comes to any other potential claimed exceptions, such as the emergency aid exception, it was clear from the detectives that looking through the phone, the seizure of the phone, this was in order to further investigatory purposes. This was not a situation where they were seeking to render any emergency aid. The community caretaking exception to the warrant requirement absolutely doesn't come into play. The phone posed no danger. There was no community protection purpose. This was purely an investigative seizure. As to the attenuation for this warrant, or for the seizure, there is no attenuation from the moment that Detective Tagler took possession of that phone, handed it off to Detective Acosta, and then handed it off to the Orange County Sheriff's Office. I apologize. There were no intervening circumstances, and this was one continuous chain of possession by law enforcement. So, essentially, the seizure, Your Honor, there's no warrant that's been sought. There's no exigent circumstance that allows law enforcement to collect this beyond the mere claim that they could just unilaterally take it. So for the seizure itself, we would argue that that's for.
Thank you. State, would you like to reply on a motion by motion basis? That'd be helpful for the court.
In the meantime, I know the defense cited some of the case law from their motion. I did have the opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct cite or a copy of the case, I would appreciate it. I could not find Appellate v. State, the site that you cite. I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable. Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on a USB organized by motion so that it was easier to be accessible rather than providing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is. Exigent circumstances, there's also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. v. Babcock, State v. Darter. The state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances. The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone, but he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers placed the phone in airplane mode to prevent that seeking. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate it? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began populating on the phone. And that's the 2 a.m. population that Sergeant Stamanik mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction of evidence. There was also testimony that even though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard. Probable cause plus exigency. Everything that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and going to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in this particular hearing. There are multiple inconsistencies. All of these things lead to probable cause and exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead, take my phone. the law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they've secured probable cause. That's not the standard here because the state's relying on the probable cause plus the exigency to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-prong analysis as to probable cause and the exigency, again, when it comes to the exigency, the direct testimony that was listed during the hearing is that to law enforcement, there is no exigency at the point that the phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Acosta, the detectives on scene, were thinking as to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that makes sense. Moving on to the second motion, if Your Honor's ready.
Mr. Johnson, I'm ready.
Yes, Your Honor. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant search of this phone. There was no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Sterns, had indicated, "Yeah, that's fine." When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" and Mr. Sterns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to navigate through the rest of the phone, through additional screens, not consent to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Sterns agrees, but again, this is limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Sterns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search of the call history in this case. So that is completely outside the scope of the searching of the maps the history photo or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Sterns' freedom to leave. While the state is going to argue that he was free to leave, and the detectives stated that he was free to leave, no statement was ever made to Mr. Sterns that he was able to leave the scene at any time. Instead, what happened is that...
Was that required, or is that a factor to be considered?
It's a factor to be considered. And when considering that factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Sterns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has the scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Sterns feeling that he was not free to leave. When we're looking to any potential course of police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Sterns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent. So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Sterns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent is limited. And while the detectives and the state want to argue that, well, he stood right there and never said no, Your Honor, some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for him. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Sterns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Sterns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation. When we're looking to the actual physical state of Mr. Sterns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. We know law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process. When we look to the standards here again, it's not what law enforcement believes that Mr. Sterns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of, you can either consent or we can get a warrant. At that point, Mr. Sterns' ability to consent has been tainted, it's been coerced, and for that reason we would argue that all of the searches of the phone violate the Fourth and Article 1 section.
Thank you. Ready?
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court is that the defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of Ms. Soto's vehicle. There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is, this conversation happens, the detective is looking at the defendant's phone. Subsequently, the detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. there's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
This is information that she had prior to giving the phone back, correct?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter, but it could have been before. My position, the state's position is it's during this time frame where she's asking.
The argument of the state was that she asked to take a picture of the history, looks at the call history.
She takes because it's what a reasonable person would understand the interaction is going to be. My position is that she uses general term history, and then she eventually goes into the call history.
Is that in the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument? Is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone, because she asks him to unlock the phone. They have a conversation. She brings up that the call log. She said, I also noticed, I was checking your call history. I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's when the discussion about the
factory reset
occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
The probable cause.
Yes, yes.
Sorry, I didn't mean to misdirect you.
So it's at that point that there's a seizure. There's some other information that's ascertained by law enforcement, and then they do a second interview with Mr. Sterns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent to forensically download the phone. It's not very long after their initial introductions on the audio recording. She says, I told you I was going to hold on to the phone. We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that that statement is phrased, it is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent. If the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement was seeking a complete download and to go through the entirety of the phone by the way that that conversation is had, because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had, and the lack of coercion by law enforcement towards it. In fact, the defendant was actually free to leave and did leave the apartment complex after this second interview. He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle. That goes to any coercive nature argued by the defense. The state also relies on the same factors as permitted by case law. whether or not the defendant was free to leave, whether there was any course of police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's...
I think as fast as I type, so I was with you up to extent of cooperation.
Extent of cooperation or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence would be found. All of these factors should be considered by the court in determining the defendant's voluntariness of consent. So the state has to show that the consent was voluntary by clear and convincing evidence, and the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard for consent is whether it was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent. So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And at no point did the defendant intend or verbally or physically or any other way communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you. Brief rebuttal. As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
All right, hang tight. Feed just decided to stop. Come on. Somebody's got to kick it. All right, hang on. Hang on. Yeah. Seems like something happened with the feed, you guys. All right, we're gonna hang here for a moment. Seems like something. Yep, the feed just like froze. Well, that's a bummer. I want to hear this. no, now what? Yep. This happened last time. The feed goes dark and then they came back. So we'll just hang here for a minute. Because they're going to be over in like 10 minutes anyway. Oh, yep. Now we got the live view. There we go. Oh, nope. Oh, Jesus. Sorry, guys. That was not me. This is what you see. Okay. Yeah, they just like ended the feed. Oh, and now they're showing that. Oh, my goodness. So that's what you see when I was down at Sarah Boone using Scott's equipment. The live view. Oh, yep. Feed did not like the defense. Yeah, feed's been factory reset. Wow, they're just going crazy. All right, we'll stay here. Maybe they just forgot to plug in their power. It happens. Live views only last for so long. And they're going to be done at 5 anyway, which is only like 7 minutes. This is brutal. All right. Well, in the meantime, I'll do a little recap. All right. So there were 3 motions, I believe. They had only gotten through 2, or maybe there were only 2. Anyway, it's motion to suppress. They want to suppress A, the search, and then B, the cell phone extraction itself. Of course, the state or the defense wants to dismiss it. But the state's like, well, the factory reset happened when Madeline, I should say, or Maddie went missing at the same day. Probable cause is so they have to prove probable cause as well as I've never heard this word before. Exigency. I don't know. That's a new one on me. I'm sure you guys are probably more familiar with it than I am. Wow, that really stinks. All right. No, we're not going to go there. All right. Well, we'll just hang here until it kicks in. So the probable cause was that Maddie went missing the same day that he does this factory reset. He's the last one to see her. He dropped her off at school, so that's that. Then the second one, the second one was more for how Detective Tagler went about, seizing his phone, if you will. It wasn't. She just asked. She said, "Hey, can I look at your maps?" And he's like, "Sure," and he hands it over. But then they're saying, now defense is saying, well, she did more than just look at the map. She started going through other apps. She looked at, his call history. So they're talking about the Fourth Amendment, searches and seizures. That he was like coerced. It was 50 to 60 degrees. End of February, Florida, Orlando. It can't get down into the 30s, but it was the end of February. He had been up all night. He had flip-flops on and khakis and yada, yada, yada. So let me pull this up. We'll go here. Oh my, what's going on there? Not sure why that's like that. Okay, let's do that. So I don't know. I don't know. State says Sterns didn't ask for his phone back at all. So there they are. There are our players for this sad, our actors in this sad player. I guess so, Lacey. They were going to be done at 5 anyway, which is 5 minutes from now. I'm looking at the other feed, and they're just it's the local affiliate, Channel 35 in Orlando, and they're just doing their news right now. The other feed we had just kicked us off to a completely different feed. So let me go back to that. Maybe I can. They're going to be done anyway in 5 minutes, so I don't know if we'd really catch much. But you know what, guys? Next week, we're going to do a really deep dive. Hold on, let me just try. Let me just try this. Let me reset it. Something happened with their live view, which is what the whole thing is, to get, Yeah, no, it's showing Karen Reed, and it's Court TV, so not going to go there. So, all right, I'll update you next week on this, because next week we'll do a deep dive. Today was just kind of, well, following these two hearings. One was yesterday to not even have today. That was denied, so we got two today, so now the judge has to decide. This is pretty big. If this judge denies his cell phone coming in, that's pretty big, right? Because there was all kinds of things found on that cell phone. So this is a big decision. We'll have to see what happens. I will update you guys next week on the decision, if indeed he rules from the bench. He may wait. He may wait. So Selena, next week we're going to do a deep dive because he's starting on the 5th of May. So we have all next week. So we're not covering Karen. We're not covering anything else. We're going to focus on Stephan. So next week we're going to get our hands on whatever we can get our hands on, and we're going to play everything and anything. We're going to play Jennifer Soto's interview, Sterns' interview, the jailhouse calls, whatever we can get our hands on. Grizzly has the live feed. Well, how did she do that? Because she's Grizzly, right? Because Grizzly's Grizzly. Let me see what feed is she using. Let's see. Well, I'm not going to play her feed because that's just not going to happen. But how did she get the feed? Unless that's, let me see. Is she live or is she... I can't tell if she's live or not. Because I'm on the local affiliate that's there in the courtroom, and I don't know how she's got that feed. Yeah, she might be behind. That might be behind because I'm on the courtroom. I'm on the affiliate that is in the courtroom, and they're not airing it. So she may be behind. I don't know. I'm not going to listen in. She's an hour behind, so yeah. So thank you, Speed Racer. But if she's an hour behind, then she's gonna run into the same problem because I'm literally on its local, its affiliate, and they are not showing it. Local news is coming up. Yeah, and in this chat, what the heck? We're going to miss the end of the hearing. Hello, what happened to what we were watching? What happened to the feed? Where's the Sterns? That's what's happening in this other chat. So something happened. Something happened with the feed. So people in that chat, which is the local channel, and I know these guys. When I was at Sarah Boone, I got to know the camera operator and the reporter. So did Jules. Jules was in the courtroom and she got to... Yeah, everybody in that chat's like, seriously? This is so messed up. What the heck? We're going to miss the end of the hearing. Hello? What happened to what we were watching? We need something more than local feed, unfortunately. So, feed's going to crap out on Grizzly too. If you guys want to go jump on Grizzly's chat and say, hey, guess what? Feed's going to crap out on you. Yeah. Everyone's looking at firefighters. Yep. If you guys want to go, bust in on Grizzly, say, guess what, Grizzly? The feed's going to go down. She probably won't appreciate that. I know I wouldn't. Or maybe I would. I don't know. Yeah, if you guys want to go over there, that's cool. So, all right. So we're done for the day. That's it for today. Thank you for watching. We're going to finish up on Massachusetts versus Turek. We have 2 more days of that. And then next Monday, all next week, we're going to do Stephan Sterns. So if you guys are into it, cool, join us. And then May 8th, theoretically, his trial starts unless they kick it down the road. So we'll see. Yeah, don't be that guy. Don't be that person that goes into Grizzly's channel and say, I'm looking at her chat. Nobody said anything. Yeah, nobody said, it's going to go down. It's going to go down. So, yep. So anyway, yeah, Grizzly's great. No spoilers. Right on. Joe, what? No Lori Daybell recap? I know, right? Oh, wait, something. Oh, wait. No, that's something else. I know. I feel lost, Joe, without doing a Lori Daybell. Oh, wait a minute. Okay, wait. Hold on. Oh, that stream's going to end. So then it ended. So they officially ended that stream. So, yep. Grizzly's going to run into that. Oh, I can't wait to hear what she has to say. She's going to be like, what? I may watch her just to see what she says. All right, so Massachusetts versus Dr. Turek. We're going to finish up that. We have 2 more days left, so that's going to be Thursday, Friday. And then next week is going to be all Stephan Sterns. If you guys are into it, which I hope you are. We had about 130 people watching, so I hope you guys will join us for that. And then the following week, he's going to start. And then Lori Daybell, yeah, we'll pick back up on her. She's going to be in June. So, Jenny, wow. We've talked about you often. We were wondering where you are. Good to see you. I hope all is okay with you. OnlyFans says, Joe Schmo, I'll give you a retrial soon. And Shirley Roth, thank you all once again. Yep. All right, guys. Thank you for joining us. Oh, she just barely lost the court feed on Grizzly. Oh, is that where she is? Yeah, there. Yep. She's like, yep, I'll tell her. Yep. Feed gets killed. Oh, Aaron's in there too. All right. I'll let Aaron handle that. So thanks, guys. Appreciate you. Thank you to Aaron. Thank you to our mods. Please join us tomorrow if you're looking for something other than Karen Reed. We're going to be doing Massachusetts versus Turek, which is it is in the exact same courtroom as Karen Reed, so you might have some weird flashback moments. But if you don't want to do Karen, come on over. We're doing that. And that trial was just a couple weeks ago, so it's not like it's a huge rewatch, but it is. I think it ended April 10th. And then next week, we're going to do Stephan Sterns. So appreciate you guys. Thank you so much for hanging out with us. And I will see you. Hopefully this will work. I'm going to play my outro from here. It's a different scene, but thank you for joining us. We'll see you guys hopefully tomorrow. And if not, then definitely next week. Have a good one. Bye. I thought that would happen. Let me come over here. I'll come over here. All right, hold on. I'll come here and I'll leave you with Super Ball. She's like blasting out the the camera. All right, I think it'll work here. All right, guys, have a good one. Bye.